Oh, your pardon.
Further hearing in the appeal Miller and others against Ministry of Justice.
Yes, Mr. Chairman.
My ladies, my lords, may it please the court, I appear with Mr. Charles Bourne QC for the respondent to this appeal, the Ministry of Justice. My learned friends Robin Allen QC and Rachel Krasno QC appear for the appellants, who are all former fee-paid judges. It's been agreed that I will go first at this stage of the appeal for a reason that I will explain in a moment.
I think they're pretty apparent.
I'm grateful, my lady. The court, I've appreciated, although I think not all members of the court were here on the previous occasion, the court is aware that this is the renewed hearing of this appeal, having been argued in this court in March 2017. The case was then referred, as this court knows, to the Court of Justice. I say the case of O'Brien was referred to the Court of Justice, and the Miller case was stayed pending the outcome of the O'Brien appeal. Now, both O'Brien and Miller are claims, of course, brought under the Part-Time Workers Regulations 2000 by fee-paid part-time judges on the basis that they were entitled to the same pension as full-time judges who were engaged on the same or similar work. That point of principle has been definitively decided in their favour, and there's no issue, of course, remaining as regards whether they were right in law on that matter. The two remaining issues, which were the subject of what I will call, if I may, O'Brien 2 and Miller, were different. The question in O'Brien 2 was whether Mr. O'Brien, whose service started before the date for transposition of the Part-Time Workers Directive in 2000, but continued after until 2005, whether he was entitled to a pension in respect of his service, not only in respect of the period after 2000, but also in relation to his service prior to 2000, despite the fact that it had been lawful to discriminate against part-time workers in the period prior to 2000. So O'Brien, too, was about the temporal scope of the Part-Time Workers Directive and, inevitably, its impact upon the part-time workers' regulations. And as the regulations were enacted to implement the directive into domestic law, this issue required consideration of a principle of European law that is known as the future effects principle. And under the future effects principle, new rules apply, unless otherwise specifically provided, immediately to the future effects of a situation which arose under the old rule. The Miller cases, in contrast, are more traditional time limit cases. The question in Miller is whether the primary time limit for an employment tribunal complaint by a fee-paid judge who is denied pension rights runs from the end of his or her relevant period of service, as we respectfully submit, or whether it runs from a later date, which is the date when the judge reaches retirement age and collects or would have collected her or his pension, as the Miller claimants contend. The primary time limit, as I'll show the court in a moment, is set out in Regulation 8 of the Part-Time Workers Regulations, and that provides that time runs from the end of the period of less favourable treatment. As I've already mentioned, after the hearing in March 2017, this court, by means of a short judgment, referred the matter to the Court of Justice, and on the 7th of November 2018, the Court of Justice handed down judgment in O'Brien 2, and I'll take you, of course, to that shortly, but the conclusion that was reached on the question referred was that the Part-Time Workers Directive must be interpreted as meaning that in the case such as that in issue in these proceedings, periods of service prior to the deadline for transposing the directive must be taken into account for the purposes of calculating the retirement pension entitlement. Now, in light of that ruling, we fully accept that judgment must be entered in Mr. O'Brien QC's favour in his appeal to the Supreme Court, and we've at no point tried to argue otherwise. However, we respectfully submit that the position is different in the Miller time limit appeals because we respectfully submit that the analysis of the relevant principles as set out by the Court of Justice in O'Brien 2 lends what we say is conclusive support to our argument that time runs from the end of the relevant period of service, not from the date when pension would have been taken. And in essence, this is because the Court of Justice, we say, reiterated that a right to a pension is definitively acquired at the time of service, and we say that this confirms our argument that the less favourable treatment takes place at the time of service. And that means, in turn, we submit that the relevant time limit, which is set out in Regulation 8 of the regulations, runs from the end of the period of service, that being the period of less favourable treatment. And since it's us who are seeking to persuade you that the outcome of O'Brien 2 did not determine Miller in the Miller claimant's favours, it's for that reason that I'm going first. May I begin by summarising why it is, in a few sentences, why it is we submit that O'Brien 2 is in our favour for the Miller appeals, notwithstanding the conclusion in O'Brien 2. And it's this. There are two separate concepts, we say, as the Court of Justice has made clear. The first one is that when pension rights, or is concerned with when pension rights are definitively acquired. And O'Brien 2 confirms that they are definitively acquired during service. And we say that that is the concept that matters for time limit purposes, because that is when the less favourable treatment takes place. There is a second and separate concept, which is when the legal effects of the discriminatory treatment are exhausted, or to use the language of O'Brien 2 at paragraph 35, when the legal situation of the worker must be considered definitive. And this is a different point. And where, as with these cases and with Mr. O'Brien's case, somebody's service straddles the date upon which the new law comes into force, the legal situation of the worker must be considered definitive when the pension comes into payment or should have come into payment. And that is the relevant concept for the purposes of the future effects principle, but we respectfully say it's not the relevant concept for time limit purposes. Now, I fully accept that this may sound like a narrow distinction, but it's one that is identified and applied, we say, by the Court of Justice in O'Brien number 2.
And of course, it also leads to a difference in treatment between those fee-paid part-time judges who happen to stay in the same office throughout their service, who can simply claim at the end, and those who go from office to office, sometimes different fee-paid, sometimes fee-paid, salaried, etc., etc. So it would introduce a difference in treatment between those two groups of people, which could lead to all sorts of other arguments,
Well, my lady,
which are not before us at the moment. But
no. But my lady's right. The logical consequence of my argument is that that difference in treatment exists.
Yes.
We wouldn't say it's introduced, but it does exist, yes. And we...
Yes, I'm trying to get my head around this. Where you have a succession of appointments, then each one is sort of, you have to claim at the end of that appointment.
That's what we say, yes.
But that doesn't stop you claiming for the next one at the end of that appointment.
Quite so.
And this applies, the whole point of the tribunal's reorganisation was to sort of treat the tribunal judge as having a sort of separate status. But you say that nonetheless each of these appointments has to be sort of treated as separate somehow.
Yes, my lord, I'm afraid I'm not sufficiently familiar to know the timing of the reorganisation.
No, I don't suppose it's relevant, but it does seem all very odd. Anyway, there we are.
But the key distinction, which I'm afraid I'm going to be emphasising during my submissions, is between the period of service and the point at which you retire, because that's the key trigger in relation to the claims in issue, and it's the one that really matters for the vast majority of these cases. So we recognise that in its judgment that led to the reference being made, the Supreme Court posited, that the majority of the Supreme Court posited the proposition that the unlawful discrimination takes place when the pension falls due for payment. But we respectfully submit that that was not adopted or endorsed by the Court of Justice, but rather the Court of Justice endorsed the view previously expressed in the case of turnover, that the right to a pension is definitively acquired at the time of service. And indeed, we will say that it's clear from the text of the O'Brien judgment that the Court of Justice regarded the less favourable treatment as taking place at the time of service.
So if you had somebody who completed their period of part-time service before the directive was due to be transposed, O'Brien teaches us that they are entitled to a pension which takes account of their period of part-time service, but you would say that that entitlement is in practice barred by a time bar unless they made a claim within the statutory period of the end of a part-time period of service.
Well, not quite, because we say that the premise isn't right, that paragraphs 36 and 37 of the Court of Justice's judgment in O'Brien 2, we say makes clear that if all of your service is before the new law comes into force, then you can't bring a claim, even if the point of your retirement is after the new law comes into force. It's only if some of your service is after, in fact, 7th of April 2000 in this case, it's only if some of your service is after 7th of April 2000 that the claim can proceed. And we respectfully submit that that shows that the touchstone, so to speak, is retirement. It is not retirement, it is service. May I just show the court that paragraph now? Or those paragraphs now?
Yes.
It's in the core volume. The judgment itself starts at page 2944. It's in the supplement to the core volume, second appendix to the core volume. And I will be coming back to this, I'm afraid, but page 2950 is the two key paragraphs, three key paragraphs.
Sorry, which page again?
2950, my lord.
Totally confused.
I found it in Authorities Volume 1, Tab 7.
The reference is 3241.
Oh, it's this one.
It's one of those very slim ones.
Yes.
My lady may have the big core volume from the 2017 hearing.
No. What I'm looking at is the electronic number, which you haven't given me.
I thought I had it, 2950. Yes, so 2950, my lady should have it
No,
on the electronic version. In that case, sorry, may I just... We did...
I see. Yes, I do. It's in two places, isn't it? That's what's confusing me. I'd found it anyway, but at a completely different page number. Forgive me.
This is 3241.
That's right, that's where I'd found it, yes. But if it's in two different places and they're both identical, that's fine. So what are you...
So I will, as I say, come back in greater detail to look at this judgment, but I just wanted, for now, to show 35 to 37 in the judgment of the court. The court says this: with regard to the argument of the UK government that the calculation of the period of service required to qualify for a retirement pension should be distinguished from the rights to a pension, it must be noted that it cannot be concluded from the fact that a right to a pension is definitively acquired at the end of a corresponding period of service that the legal situation of the worker must be considered definitive.
I'm sorry, where are you reading?
Paragraph 35, my lord.
Oh, thank you. Right. Yep.
So, having recognised that the right to a pension is definitively acquired at the end of a corresponding period of service, the court goes on to say that it doesn't follow from that the legal situation of the worker must be considered definitive. It should be noted in this respect that it's only subsequently and by taking into account relevant periods of service that the worker can effectively avail himself of that right with a view to payment of his retirement pension. And then it's 36 and 37. Consequently, in a situation in which the accrual of pension entitlement extends over periods both prior to and after the deadline for transposition of the directive, it should be considered that the calculation of those rights is governed by the provisions of that directive, including with regard to the periods of service prior to its entry into force. Such a situation is, in that regard, to be distinguished from the situation invoked by the United Kingdom government in support of its arguments of the colleagues of the claimant who retired before expiry of the period for the transposition of the directive. And then, in the operative part of the judgment, it said that the directive must be interpreted as meaning that in a case such as that in issue in the main proceedings, periods of service prior to the deadline for transposing the directive must be taken into account for the purpose of calculating the retirement pension entitlement.
But that's not saying that that's not saying that a period of part-time service only counts if it spans the transposition deadline. It's simply, that's the specific situation considered in 36, but it's not saying it's only in that situation. 37 is distinguishing, that was the fact of the O'Brien case. 37, of course, is distinguishing the situation of somebody who actually retired before the due date for transposition. But if you had somebody who worked part-time before 2000, continued working full-time, and then retired after 2000, then, well, I've certainly read this judgment as making it absolutely plain that the period of part-time service counts towards the pension.
I fear, my Lord, that I'm going to try and persuade the court to take a different view of these passages.
That's the question. If you look at the question we asked at the top of page 3240, we asked, does the directive require that periods of service prior to the deadline for transposing the directive should be taken into account when calculating the amount of retirement pension, if they would be taken into account when calculating the pension of a comparable full-time worker? So we weren't, there was no issue in the reference about people whose periods of service were, part-time service were limiting it to people whose period of service happened to last before and after the transposition date.
My Lord, in that case, I asked rhetorically why the court would qualify what it says in paragraph 36 by referring to a situation in which the accrual of pension entitlement extends over periods both prior to and after the
because
deadline.
That was Mr. O'Brien's case, paragraph 24. In the present case, Mr. O'Brien served as a part-time judge on a fee basis between 1978 and 2005.
My Lord, yes. However, in my submission, there would be no need or purpose behind the Court of Appeal, the Court of Justice, making any reference to the factor that the accrual of pension extends both before and after.
And so in the dispositif, you say that we should read, in a case such as that at issue, you mean this ruling only applies to cases where the part-time service was both before and after the implementation date?
My Lord, yes, that is my...
Mr. Kavanagh, do you think that we ought to have a little greater focus on the issue by looking sooner rather than later at Regulation 5 and 8?
Yes, of course. Unless my Lord Reid has any further questions at this stage, that's what I'll do. And in fact, what I was proposing to do, so to speak, to clear the decks, was to refer the court to what we say are 6 pieces of common ground which narrow the issue of dispute between us, and the first of which will involve examination of Regulation 8, Regulations 5 and Regulations 8. So there are, in our submission, 6 propositions that are common ground. The first is that the relevant limitation provision is that which is set out in Regulation 8 of the Part-Time Workers Regulations. The document or the provisions can be found at page 3280 in the memory stick, which is volume 1 of the authorities, tab 12. Regulation 5 begins at 3279 and provides that a part-time worker has the right not to be treated by his employer less favourably than the employer treats a comparable full-time worker, at B, by being subject to any other detriment by any act or deliberate failure to act of his employer. And then
Can I just ask a question there? You've skipped A.
Yes.
You think this is a detriment case. I was wondering whether the proper analysis was that the less favourable treatment was as regards the terms of his contract, which didn't include the pension provision, which should have been included.
Well, my lord, there is an issue which I think has been argued very recently in this court in a case called Gillam and the Ministry of Justice as to whether judges have contracts or not.
Oh, I see.
And that's the reason that
But I thought that there was, my reading suggested that there was a move to read the word contract rather liberally and sensibly.
I'm quite content to do so. It makes
But
no
you think
difference.
it's a B anyway?
I think it's a B, but it
Very
makes absolutely no difference. And I'll show the court in a moment there's a reference to contract in the time limit provisions, which no doubt is broad enough to
Thank you.
comprehend office holders even if they don't have a contract. On the next page, 3280, is the time limit provisions, and there are two time limit provisions. 8.1 provides that a worker may present a complaint to an employment tribunal that his employer has infringed a right conferred on him by Regulation 5. 8.2 is the key, what the parties have called the primary limitation provision, that an employment tribunal shall not consider a complaint under this regulation unless it's presented before the end of the period of 3 months, and we don't need to worry about the proviso, beginning with the date of the less favourable treatment or detriment to which the complaint relates, or where the act or failure to act is part of a series of similar acts or failures comprising the less favourable treatment or detriment, the last of them. So that's the provision which we say fixes the running of time from the conclusion of the period of less favourable treatment.
Not very cleverly drafted, if you look at 5, because in 5, detriment is within treatment, whereas in 8, detriment is opposed to treatment. However, we'll cope.
Happily, that at least is not one of the issues that the parties, I think, need to argue about. I should show you, however, 4A, 8.4a, which provides that for the purposes of calculating the date of the less favourable treatment or detriment under paragraph 2, where a term in a contract is less favourable, that treatment shall be treated subject to paragraph B, which doesn't concern us, as taking place on each day of the period during which the term is less favourable. I fully and happily accept that it may be necessary to read the word contract purposively there so that it can encompass judges whether or not this court ultimately decides that judges work under a contract. But we say that 4A is more of an illustration than an expansion of the time limit that is set out in 8.2, and indeed that, if anything, it focuses attention on the period in which the person is serving under the terms and conditions concerned.
But where you have a series of appointments, why is that not covered by the second part of 2?
Well, because it's not a series of appointments that the second part of 2 is directed to. It's a series of similar acts or failures. I should say,
if you're unfavourably treated in your post as an employment judge, and you then move on to being unfavourably treated in your post as an asylum judge, surely you look at the last of them.
well, my lord, may I caveat what I say by saying that this isn't one of the issues that's before this court. It's not one of the points in this appeal. But I think the Ministry of Justice's position is that nevertheless each separate appointment counts separately for the purposes of the time limit that applies under paragraph 8.2, regulation 8.2. There is what the parties have called a secondary time limit, a sort of escape valve, which is at 8.3, that a tribunal may consider any such complaint which is out of time if, in all the circumstances of the case, it considers that it's just and equitable to do so. So there is a broad, just and equitable extension power that exists in the legislation. My ladies, my lords, I said that there were 6 propositions which I think are common ground. The first one is that this is where the time limit is to be found. The second one is that there is a safety valve, as I've just pointed out, which is regulation 8.3. The third proposition, which must be common ground...
Well, how do you suggest that the 8.3 should be applied?
It's been tested in this case, and the employment judge decided that it wasn't just and equitable to extend time if time ran from the end of the period of service in these cases. That was then appealed to the Employment Appeal Tribunal, and the appeal was dismissed. The judgment of the Employment Appeal Tribunal is in the bundle at page 3390. That's volume 2 at tab 18. Perhaps I can just show you it. And that appeal, however, has not been pursued any further. So in relation to the appellants before you, their just and equitable secondary time limit argument has been rejected. And that was primarily, as one sees from paragraph 22 of the EAT's judgment at page 3402, because all of the claimants, apart from 2 who are concerned today, had known about the litigation, the O'Brien litigation, for many years before they made their claims, most around the time of the judgment of the Court of Appeal, although 2 had known from the start. I'm reminded by Mr. Bourne that although that's the position in relation to these claimants, there are other claimants who have brought separately just and equitable extension claims in the tribunal which are currently being heard. So although the Miller appellants have lost the just and equitable argument, that's not necessarily the case for lots of other appellants who are out there, or lots of other. Some have succeeded. In fact, Miller succeeded on just and equitable, which is why she's not here. But the 4 who are here failed on just and equitable. And may I say that all of the form, my learned friend is helpfully, when he is on his feet, going to give you the bare facts, or a document containing the bare facts of the 4 claimants. And each of them brought their claim before they actually would have retired and received a pension. So this is not a case in which any of the claimants were misled into thinking that they could wait until they reached pension age before bringing their claims.
So the SFI we have, which tells us about the appellant, that's
the appellant, sorry to interrupt, my lord,
yes.
but the appellant, I think, is Mr. O'Brien.
Oh, that's
the
referring to
SFI
O'Brien. Yes,
was a combined SFI for O'Brien and for Miller. And it's page 2889 that the facts of the Miller appellants are set out in very short order.
Yeah, yes, okay.
If I may just browse a second. The document on the bench updates those facts.
So we're agreed what the time limit is. We're agreed that there is a just and equitable extension, but not one that succeeded for these claimants or these appellants. The fourth proposition, which is common ground, is that...
So the third is that it failed?
The third is that it failed.
Okay.
The fourth is that domestic law time limits apply even to rights derived from EU law, subject, as this court knows very well, to the twin exceptions of effectiveness and equivalence. That you cannot rely on a domestic law time limit if it would make the claim impossible in practice or excessively difficult, or if it's contrary to or less favourable than a similar action of a domestic nature.
That would obviously be the case if the relevant date, was actually prior to transposition. But your answer to that is, if a relevant period ended prior to transposition, you have no entitlement under O'Brien. That's your...
Well, that's my first answer. My second answer, if I'm wrong about that, you have the just and equitable extension, because it plainly wouldn't be equitable to deny you a claim because you didn't bring a claim at a point before you could know you had a claim. So, and that brings me on to my fifth point of common ground, which is that there is no breach of the principles of effectiveness and equivalence in the present case, because the just and equitable extension means that we would respectfully say it's just not possible to contend that it's not possible in practice to bring a claim. And there's never been any suggestion of a breach of the principle of equivalence. And the sixth proposition is this, that if the issue in this case was not pensions, but the less favourable treatment concerned any other term of employment, the period of the less favourable treatment would be the period of service, so that time would run from the end of the period of service. And so, for example, if an employer underpaid salary or commission during service, even to a very great extent, time would still run from the end of the period of service, even if this meant that the worker was short of money later in life. My lords and my ladies, having, I hope, cleared the decks, may I come on to O'Brien 2 and start by reminding us all that the issue in O'Brien 2 was not time limits, but whether the periods of service prior to transposition must be taken into account for the purpose of calculating retirement pension entitlements. The Court of Justice, of course, said yes to that question, but it's crucial for present purposes, we submit, to take account of the process of reasoning that led to that conclusion. And there were two possible routes to the conclusion that was reached. The first one, route 1, would have been the more straightforward, and that is simply on the basis that the less favourable treatment didn't happen until retirement date. If that had been the route that had been taken by the Court of Justice in O'Brien, then I would not be standing here before you, because O'Brien 2 would have supported the Miller claimant's contention that time doesn't start to run until retirement, because that's the point at which less favourable treatment takes place. The second route, which is the one we say the court followed, is a more complicated route. In the second route of reasoning, the position is that pension rights are definitively acquired while service takes place, but nonetheless, the effect of the future effects principle is that service, even before the new law comes into force, must be taken into account, because although the right is definitively acquired at the end of service, the legal effects are not exhausted until retirement. And we respectfully submit that the Court of Justice adopted that second analysis, and that second analysis positively supports our argument on time limits, because it's wholly consistent with the conclusion that less favourable treatment takes place during service, not at the point of retirement. Now, may I take the court...
Sorry, how do you define the less favourable treatment that takes place during service?
Because you are working for less favourable benefits than your colleagues.
Working without having a pension right.
Yes, you're not accruing a pension right. It's the same way if you're being paid less. The consequences are felt later, but the harm is being done. The less favourable treatment is taking place at the time of service.
Can you give us the paragraph numbers for this?
Yes, my lady. Absolutely. So sorry, I didn't mean to
No,
interrupt.
you can give us the paragraph numbers for the CJEU.
Yes, I will indeed. What I'm going to do, I was forensically setting out the proposition, and I'm about to take the court to the CJEU judgment. There will, however, be two digressions, and the first is to take the court to the judgment of this court that made the reference to the Court of Justice, which you'll find at page 3230 which is volume 1, tab 6. So it is in the authorities volumes rather than in the core bundle. And the particular passage I wish to remind this court of is at page 3234. It's the section headed The View of the National Court. It's the judgment given by my Lord Reid on behalf of the court. Or the, excuse me. And paragraph 19 states this: the majority of the court are inclined to think that the effect of the directive is that it is unlawful to discriminate against part-time workers when a retirement pension falls due for payment. Now, I address head-on and fully accept that that is against my submission, because we say that the discrimination doesn't happen when the retirement pension falls due for payment. It happens during service. But I carry on. The directive applies ratione temporis where the pension falls due for payment after the directive has entered into force. Insofar as part of the period of service took place prior to the directive's entry into force, the directive applies to the future effects of that situation. However, the Court of Justice has not as yet considered the argument that if, following the ten-over line of authority, an occupational pension is treated as deferred pay, the right to which is acquired at the time of the work to which the pay relates, then it follows from the general principle of non-retroactivity that the directive does not alter or affect rights acquired, or in Mr. O'Brien's case not acquired, before it was brought into force, there being no provision in the directive which overrides that general principle. Although the majority of the court are inclined to think that ten-over was concerned with the exceptional barber limitation, which doesn't arise in the present context, the correct approach doesn't appear to the Supreme Court to be at clear, and the case was therefore referred to the Court of Justice. May I now bring the court to the judgment itself, and as has already been noted, it's in two places, perhaps unhelpfully, but at page 3240 and 3241, perhaps starting at 3239, are the relevant parts of the judgment. I hope the court will forgive me. I'm acutely aware of the relatively short period. I don't want to take up my time unnecessarily with matters that I might make, points I might make more elegantly, given more time. In paragraph 20 and 21 of the judgment, which is at page 3239, the court recalls the preliminary view expressed by this court that I've just taken the court to. So, according to the order for reference, most of the members of the Supreme Court are inclined to think that the effect of the directive is that it is unlawful to discriminate against part-time workers at the time when a retirement pension falls due for payment. In their view, the directive applies ratione temporis at the time when the pension falls due for payment, after the date at which the directive entered into force. In cases where part of the period of service took place prior to that date, the directive applies to the future effects of that situation. I just mention that last sentence because it's pertinent to the question that was asked of me by my Lord Reid a few moments ago. The court then goes on to say this: however, according to the order for reference, the Court of Justice has not yet considered the argument that a pension should be, as may be inferred from ten-over, be considered to be deferred pay, the right to which is acquired during the period of service to which the pay relates. If such an argument were accepted, the directive could not, in accordance with the general principle of non-retroactivity, affect the rights acquired, or in Mr. Brown's case, the rights not acquired. This again is taken, I think, verbatim from the order for reference. Before it entered into force, there being no provision in the directive which overrides that general principle. Although most members of the referring court are inclined to the view that the approach taken in ten-over cannot be applied, they nevertheless take the view that the correct approach to be taken is far from obvious. And it's at this point, I'm afraid, that I'm going to make my second and final digression from the Court of Justice's judgment. May I ask the court to keep, if it's feasible to do so, the Court of Justice's judgment near to hand. But I do wish, if I may, to take the court back to Tenova very briefly, which is at page 3166. It's volume 1, tab 5. And the point I want to make about Tenova, because we say that it still stands after the Court of Justice's judgment in O'Brien 2, is whereas the effect of the future effects principle is very different in judgment cases as opposed to new legislation cases, the view expressed by the Court of Justice and the Advocate General in Tenova as regards the juridical basis for pension claims supports our proposition, we say, that the less favourable treatment happens at the time of service. And that part of Tenova is adopted by the Court of Justice in O'Brien 2. So the relevant passages, they're very short in Tenova, are first to the Advocate General at page 3193. Tenova was the case, as the court will remember, about the Barber Protocol, the retrospective effect of a piece of a new judgment which changed everybody's understanding of the law. And that's different from O'Brien, which was about a new piece of legislation and its potential retrospective effect. And at 3193, at letter H, the Advocate General Van Gerven says, in practice, an employee accrues pension entitlements on the basis of his periods of service with the employer concerned. And between D and E on the following page, 194, from the legal point of view, this accruing nature of occupational pension schemes leads to a distinction between the coming into being of pension rights, namely as a result of the accrual of the pension on the basis of completed periods of service, and those rights becoming exercisable, namely when the pension falls to be paid for the first time.
But what is the situation where you serve a certain number of years on the basis of expected pension entitlement, and then the employer changes the rules of the pension scheme in a way that affects you? So you've had your service apparently accrued, but nevertheless the employer can change the terms.
What an employer can't do is change terms in relation to accrued service. Section 67 of the Pensions Act 1995. So any subsequent changes can only ever apply prospectively to future service. So you are locked in, to use that inelegant phrase, to the bundle of rights.
But it can change other things that affect the value of what you've accrued.
My lady, I'm sorry, I don't...
Well, it's fairly obvious what I'm talking about. So.
Well, I apologise, but the key proposition in my submission is that any accrued rights are and remain forevermore accrued once that service is over. The employer cannot fiddle with the ultimate pension benefits that you will enjoy because of the service that you have undertaken at the relevant time. And at the bottom of page 3194, the Advocate General says that distinction between accrual and falling due of a pension makes it clear what the court meant in Barber. Since it's the service itself and in some cases the relevant contributions which give rise to the employee's pension rights on the one hand and the obligations of the employer and the trustees of the pension fund on the other, the court clearly has in view here periods of service after the 17th of May 1990. Any sex discrimination occurring in this field after that date, owing in particular to the practice of taking account of a different pensionable age in calculating contributions, etc., thus falls under the prohibition laid down by Article 119. And finally, from the Advocate General on that next page, between D and E, here again the distinction between the accrual and the falling due of the pension helps to clarify matters. Since it's the service itself, and in some cases the relevant contributions which give rise to the rights and obligations of the employee and the employer, and or of the trustees of the pension scheme, it may reasonably be assumed that in using the expression legal situations which have exhausted all their effects in the past, the court had in view situations in which the rights to a pension had already been acquired by virtue of periods of service prior to the judgment in Barber. And we respectfully fully accept that one cannot read across the analysis of the future effects principle from Barber-type cases to an O'Brien, because a Barber-type case depended on a new judgment, whereas O'Brien depends on new legislation. But the underpinning, the proposition that it's the service that gives rise to the rights and obligations, we say remains the position under European law.
The problem in turnover and the other cases like it, which there are many, was that accrual of pension was contractual, and the basis on which the contract had been drawn up was effectively overturned by Barber. For example, women live longer on the whole than men do, and that's reflected in the pension scheme, a contractual pension scheme. But the effect of Barber was that could no longer be given effect, and because there had to be equal rights. And turnover was seeking to protect legal certainty of those who had entered into these contractual arrangements. But the whole point in O'Brien is that there was no contractual accrual whatsoever. Nothing was accruing to Mr. Barber when he was working part-time. His pension entitlement is purely the result of EU legislation as and when that came into force.
My Lord, it's the result of EU legislation applied to the period of service that took place. If Mr. O'Brien hadn't been doing any service as a judge, then he wouldn't gain anything prospectively or retrospectively.
No, of course not.
From the EU legislation. But service is still, as I've put it, the touchstone, the qualifying requirement in order to be able to bring to have your claim.
Well, the entitlement under the legislation depends on length of service, clearly, because the entitlement is not to be discriminated against, and therefore you have to be given the same, you have to be treated fairly as compared with somebody who has the same length of service as you do, but on a full-time basis. But the whole analysis based on the accrual of pension rights doesn't work. He had no pension rights. Nothing was accruing.
But he should have had those pension rights. The wrong was that he wasn't accruing pension rights during his period of service. And his claim is by reference to a comparator a salaried full-time comparator who did have the same service and was accruing pension rights during that relevant period.
Well, it sounds like a sort of game of let's pretend. Because he has to be treated fairly as compared with a comparator who was accruing pension rights, you seem to be saying, let's pretend that Mr. Miller or Mr. O'Brien or whoever it was accruing pension rights and approach time bar issues on that footing, despite the fact that in reality he wasn't accruing.
But my Lord, in a non-pensions case, if it turns out sometime after the event that a person was deprived of a element of pay, the same analysis would apply, that they would be compared with a comparator, full-time comparator who was getting a higher rate of pay, and they would get similar, retrospectively, they would be granted similar rights. My ladies, my lord, may I come back to the judgment in O'Brien 2 itself and address...
Were you looking at the court in Turnover or...
Oh, my lord, I've run out of time to do so. Paragraph 17 of the judgment is the only part of it that is of any
same point.
And the court adopts the analysis of the Advocate General. There's much more detail in the Advocate General's opinion. I'm so sorry, I should have made that point. So may I ask the court to come back to O'Brien 2. I've already shown you 20 and 21, where they identify the argument that appealed to the majority of this court first time round, which was that it's unlawful to discriminate against part-time workers at the time when a retirement pension falls due for payment. And then if we follow through the analysis of the court at paragraph 25 on page 3240, the court says it's apparent from the file before the court that judges acquire a right to a pension under the relevant judicial pension schemes in England and Wales on the basis of their pensionable service. Now, I'd accept that in isolation that doesn't really show which of the two routes I identified a few minutes ago the court is adopting. At paragraph 27, the court refers to what we call the future effects principle, which is that a new legal rule applies from the entry into force of the Act introducing it, and whilst it doesn't apply to legal situations that arose and became definitive prior to the entry into force, it does apply immediately to the future effects of a situation which arose under the old law and to new legal situations. Then at the top of the next page, paragraph 29, the court says this: it's therefore necessary to examine whether the gradual acquisition of pension entitlements over the period preceding the deadline for transposing the directive has the effect that the legal situation of the claimant must be considered to have become definitive at that date. So the court is distinguishing two things. One is the gradual acquisition of pension entitlements, which it recognises happens during service. And then secondly, whether that means that the legal situation has become definitive. And so we say what the court is saying, and what we're about to see, is that the definitive acquisition of pension benefits at the time of service is not the answer to the future effects question. It's a different question whether the legal situation is definitive. At paragraph 38, the court summarises the UK government's argument, which is that deferred pay in the form of entitlement to an occupational pension accrues in the same way as other forms of pay. In the case of judicial pension schemes, the pension is earned for successive periods of pensionable service. The pension entitlement, therefore, increases sorry, did I say 38? Paragraph 30.
30, isn't it? It's 30.
30.
Yes.
Increases, yes, the pension entitlement therefore increases as each period of service is completed. Accordingly, insofar as, at the end of each period of service, the corresponding pension entitlement acquired exhausts its effects, pension rights acquired before the final date for transposition cannot be taken into account. So they, if we may respectfully say so, correctly recognise two aspects to our submission. First, pension rights are acquired before the final date, and secondly, the effects are exhausted before the final date. The Court of Justice agreed with us on the first point, disagreed with us on the second point. In 31 and 32, the Court refers to us pointing out...
Sorry, are you reading the second part of paragraph 30 as the Court of Justice agreeing with the UK government's submission?
No, but I will do in a moment. I'm
Okay.
sorry. My Lord, what I was trying to do was identify there were two steps to our submission,
Right.
one of which I will say is accepted, the other of which, I entirely agree, was not accepted, and the second one is the one that was not accepted. Excuse me. My Lords, my Ladies, given the time, may I come straight to paragraph 35, which we say is the key part of the Court's reasoning. The Court says, with regard to the argument of the UK government, the calculation of the period of service required to qualify for a pension should be distinguished from the rights to a pension. It must be noted that it cannot be concluded from, insert one, the fact that a right to a pension is definitively acquired at the end of a corresponding period of service, two, that it cannot be concluded that the legal situation of the worker must be considered definitive. I'll come on to the next sentence in a moment. But in my respectful submission, what that shows is that the Court agreed with the first step of our argument, but disagreed with the second step. They accepted that a right to a pension is definitively acquired at the end of a corresponding period of service, although they did not regard that as being good enough to get us home because of the future effects principle. And then the court went on to say that it should be noted in this respect that it's only subsequently, and by taking into account relevant periods of service, that the worker can effectively avail himself of that right with a view to payment of his retirement pension. And that's why the legal situation is not considered definitive, but it doesn't detract from the bold statement by the court that a right to a pension is definitively acquired at the end of a corresponding period of service. And it is that proposition, we respectfully say, that matters for time limit purposes, rather than the more general question of whether the legal situation has become exhausted. And it's for this reason that we respectfully submit that far from supporting the appellant's case on time limits, this judgment supports our respectful submission that the less favourable treatment happens when the service is actually taking place. And that, in our submission, is, if I may say so, a coherent and logical legal approach on the part of the Court of Justice, because there is a complete difference conceptually between the future effects principle on the one hand and time limits on the other. They're directed at different things. The future effects principle is about the temporal scope of the remedy, whereas Regulation 8 is a classic, or Regulation 8.2 at any rate, is a classic time limit. So the effect of the future effects principle is that on commencement date, there is, so to speak, a sudden evening up of the score. You can bring in your previous service, but you still have to claim in time. Now, nobody loses out because of the just and equitable extension. If you couldn't be expected to know you had a claim at a certain point, then you will be forgiven for bringing your claim later. But nonetheless, there is a key distinction we submit between when your pension rights are definitively acquired, on the one hand, and when the legal effects are exhausted. And this, in my submission, also makes sense because, as I put it inelegantly a few minutes ago, pension rights are locked in at the point of service. It's true that you don't know what your final salary will be if it's a final salary scheme, but you do know at the end of your period of service that you've qualified for pension benefits. If you die early, you'll qualify for death in service benefits, or even if you die between leaving and retirement age, you will get your death in service benefits. So one way or another, you will get what is coming to you for your period of service. And it follows from that in our submission that the less favourable treatment takes place at the time of service. And I only have 2 or 3 minutes more, so and the point I'm about to make is dealt with, I hope, quite fully in our written case. But it's this, that we say is the conclusion to be drawn from the EU jurisprudence. It's wholly consistent with the domestic law jurisprudence, and particularly a judgment of the House of Lords in a case called Kapoor and Barclays Bank. That too was a pensions case. It was a race discrimination case rather than a part-time workers case. But in that case, in the judgment, and perhaps I don't have time to take the court to it, but it is, the relevant paragraph is quoted in our written case. Lord Griffiths, with whom all the other lords agreed, said that a man works not only for his current wage, but also for his pension, and to require him to work on less favourable terms as to pension is as much a continuing act as to require him to work for lower current wages. But in Kapoor, the court found that time ran from the end of the period of service. And we say that's quite right. The other cases, including Parry and Cleaver in the House of Lords, that say that pension is deferred pay. Very last thing I want to say in a minute is where this leaves the case of Walker and Innerspec, which was argued at the same time as O'Brien. I am not suggesting that the analysis that I put forward means that Walker was wrongly decided. And there is a key difference between this case and Walker. And can I just show you one paragraph or 2 paragraphs in Walker, which you will find in the page 2970, which is in the second appendix. take it from my closing. It's page 2969.
2969.
Walker, you'll recall, was a sexual orientation case where marriage or civil partnership hadn't been treated in the same way as marriage between a couple of the opposite sex would have been treated. And in the judgment of the majority of the court, including my Lady Hale and my Lord Reed, Lord Kerr said at the very bottom of the page, the point of unequal treatment...
I'm working from a different...
56.
It's
I'm so sorry,
56, is it?
56.
Very well.
The point of unequal treatment occurs at the time that the pension falls to be paid. Now that's contrary, of course, to my submissions. But he then goes on to say that if Mr. Walker married a woman long after his retirement, she would be entitled to a spouse's pension, notwithstanding the fact that they were not married during the time that he was paying contributions to his pension fund. Whether benefits referable to those contributions are to be regarded as deferred pay is neither here nor there, so far as entitlement to a pension is concerned. Mr. Walker was entitled to have for his marriage partner a spouse's pension at the time he contracted a legal marriage. The period during which he required that entitlement had nothing whatsoever to do with its fulfilment. So the point about Walker and Innospec is that there was no discrimination in relation to periods of service between heterosexual and homosexual workers. The problem related to marriage. The marriage in Mr. Walker's case took place in 2005 after the anti-discrimination legislation had come into force. And any time after that directive came into force, the position remained that a heterosexual retired worker could marry and thereby secure the spouse's entitlement that the case was about, but a homosexual person could not. And so it wasn't a case that had anything to do with differences in treatment relating to service. And at the very end of the judgment, if I may respectfully say so, my Lord Carnwath and Lord Hughes identified that feature. Paragraph 77 at page 2975, the lordships differed as to whether the decision that Tenova didn't apply should be decided upon until after the O'Brien 2 hearing in the Court of Justice. At paragraph 78, their lordships say that the Walker case is in any event distinguishable substantially for the reasons that were given at paragraphs 56 to 58, because on any view, he had earned a right to a pension for his spouse, and that right and the possibility of a change in his marital status should have been taken into account in the financing of the scheme. The question who qualified as his spouse fell to be answered at a date when it was unlawful under the directive to discriminate as between heterosexual and same-sex marriages. So the point, if I may respectfully say so, in Walker is that what mattered was who qualified as your spouse, had nothing whatsoever to do with service. So if we respectfully say paragraph 78 of Walker encapsulates why Walker was still rightly decided, regardless of what I say today in relation to Miller. My lords, my lady, I can see my learned friend is champing at the bit, and I have used up my hour.
Well, you've gone 3 minutes over your hour,
I will
so that
give
will
it
come
up
off your
if I
reply.
need to.
Yes. Okay, thank you.
As I just shuffle my papers around here, can I make a short point before I open out? There is an absurdity at the heart of the Ministry of Justice's position, which will not have been escaped, I'm sure, by everybody in this court. The point at which all of us in this room want a pension is the point at which we retire. That is the point at which we want it. Obviously, we want to know in the future that we may have it, but we want to know exactly what it will be at the point that we retire, and that is the point at which we want no less favourable treatment on grounds of having been a part-time worker ultimately. The case for the Ministry of Justice is it's too late to argue about it at that point. You should have argued at it much earlier on, when you've moved from one job to another, from one part-time job to another part-time job, or from a part-time job to a full-time job. And that suggests that you've got to bring the litigation, you must bring the litigation, not that you can or you can't, but you must bring the litigation, as it were, long before the key point at which it's of vital importance to you in your life. We suggest that is an absurd outcome, and we say it is not what the law says, and it's entirely contrary to the case law, particularly O'Brien CJE 2, but also the trailed point taken in O'Brien SC 2, and it is contrary to the judgment of Lord Kerr in Innerspec and Walker. We also say that it is not what you're driven to by looking at Regulation 8. Now, time is limited. I propose, if I may, in order to make sure I've covered all the ground, to go directly to my case, not to read all of it to you, but the points are all there, and I can add to them shortly as I go through. If that's unacceptable, please say so if there's any particular point you want me to pick up first. But that seems to me to be the better way of proceeding. I certainly don't need to read all of this to you, but we do, I think, need to put context on this, and what I'd like to do is to go directly to 2897 to recall what Lord Reid said was the issue about pensions for part-time judges. This is Lord Reid in O'Brien SC 2. It's in the box, and he sets out how the Judicial Pensions Act and the JPRA, there's no point of distinction between of those that you need to worry about, and I've referred only to the JPRA subsequently. It depends a little bit about when you started. The 1981 applies to persons appointed prior to the 31st of March, the 1903 Act to persons appointed on or after the 31st of March. Under the Acts, a pension is payable to any person retiring from, quotes, and these are the key words, qualifying judicial office, subject to their having attained the age of 65, and under the 1993, subject to their having completed at least 5 years' service in such office. Those are the conditions for a pension. The problem for a person in judicial office, which is a part-time office, is it was never within the scope of the definition qualifying judicial office. The comparable full-time judicial offices in every case were. The material time, full-time, and this is what's then said by Lord Reid, and I go on under both schemes, the amount of pension payable to a full-time judge is based on his or her final year's salary and on his or her number of years of service in a qualifying judicial office by the date of retirement. Then it sets out a little bit more and sets out the lump sum payable on retirement, the sum being based on the amount of the annual pension. So if you ask the question, what does equal treatment look like for a part-time judge compared to a full-time judge? The full-time judge, on the date of retirement, can do the calculation. What's my final salary? What's my years of service? The multiplier and the multiplicand are found, and then the answer is given. There's a quirk in that Lord Reid skipped over the fact that it could be your best year in your last 3 years, but that's of no importance to the point that I want to make. There's no doubt, it's accepted by my friend, that there's a right for a part-time judge to have a pro rata pension. Now, you can't say what a pro rata pension looks like exactly unless you identify who the comparator is, the full-time judge who's gone through the same offices but in a salaried full-time position and has retired. So that's the starting point. We then look at the basis of the claims, which are in 13 and 14. We've already looked at Regulation 5, and I don't need to take you through those. That's page 285. 2999, and then the issues in the appeal, and then you'll see that at the foot of 2900, I've set out Regulation 8. I am actually going to ask you, if you will please, to pick up Regulation 8, which is in Volume 1, because there's an important point here about the remedy that a tribunal can give, which I didn't put in the box, but given the way in which the case has been developed, I probably need to just mention. So if you could look at 3281, MS 3281, it's the last page, I think, of Volume 1 of the authorities. Eight sub 7 gives the tribunal two different powers, a declaratory power and a compensatory, well, three, a compensatory power and a recommendation power. So it can declare that, for instance, the absence of legislation or the absence of the inclusion of part-time work within qualifying judicial office was a breach of the Act. It could declare the amount of compensation. If it had reached the point of retirement, it could say how much pension should be given. It has a range of possibilities depending on what's appropriate at the point in time in which the litigation is brought. Paragraph 8, we can revert now to the box in the case, because there are two other bits of it which have not been fully considered by my friend, which I need to draw to your attention. You've seen the first bit, which he read, 8.1 and 8.2, but then we need to look at 4 and 5, both of which are included within the box. For the purpose of calculating the date of the less favourable treatment or detriment, and I pause there for a moment to pick up Lord Wilson's point, this regulation isn't brilliantly drawn, but it includes detriment and less favourable treatment, because detriment can be less favourable treatment, but there's a class of detriment which is not less favourable treatment. That class is the kind of treatment which is victimization, which is within the scope of the regulation but doesn't arise here. And that's dealt with, I think, if I remember rightly, it's Regulation 7. I mean, it could have just written detriment, but it puts both of them in to make it clear that Regulation 8 applies to both ordinary discrimination cases and victimization cases. For the purposes of calculating the date of the less favourable treatment or detriment, where a term in a contract is less favourable, that treatment should be treated as taking place on each day of the period during which the term is less favourable, and a deliberate failure to act, contrary to Regulation 5, should be treated as done when it's decided on. But then you get 5, which he didn't read to you. In the absence of evidence establishing the contrary, a person should be taken for the purposes of Regulation 4C to decide not to act when he does an act inconsistent with doing the failed act, or if he's not done no such inconsistent act, when the period expires, within which he might reasonably have expected to have done the failed act if it was to be done. Now, putting it bluntly, the last possible moment at which equal treatment in relation to pensions ought to be given to a part-time worker or a person who has been a part-time worker is the point of retirement. It's perfectly obvious. It's a matter of straight logic. And that's why we summarise the question for the court in paragraph 21 in the way that we have done. That is actually the question that emerges that has got to be answered in this case.
Mr. Allen, you're saying very clearly that you submit that less favourable treatment occurs at retirement.
No, I say it goes all the way through.
That's what I wanted to ask
Absolutely so.
It starts with the start of the service?
It starts
every day of the service, less favourable treatment?
All the way up to the point of retirement.
And just the middle bit. End of service, but no retirement. Does it go through that period too?
Yes, it goes all the way through to the end.
What is the less favourable treatment after the end of service, prior to retirement?
The answer is that a comparable judge, because in order to analyse less favourable treatment, you've got to think of a comparator. The comparable judge who'd gone from one job to another, typical one which I suspect all of you have done is to go through High Court bench, Court of Appeal bench, and then to the Supreme Court bench. Throughout the whole of that period, the legislation applies to you. The part-time judge, and it applies to you fully, if I can put it that way, so that all your period of service is taken into account. If we go back to Lord Reed's analysis, it's regulation, Section 3 of the Judicial Pensions and Retirement Act makes it clear it's all the service in qualifying judicial office that is taken into account to give you your pension. So you could do, for instance, only 1 year in your last office, but provided your previous 4 years were in qualifying judicial office, you get your 5 years. So the pension legislation says it doesn't care for full-time judges what your job is, provided it's within the definition of qualifying judicial office.
So, sorry, but what is the act or omission that takes place every day after the end of service, but prior to retirement?
The absence of legislation that brings into account the part-time service into qualifying judicial office continues all the way through to the point of retirement. And then
Well,
on the point
you
of
could have
retirement...
somebody who left a full-time job early,
Yes?
before the age of 65, so would not qualify for the pension until reaching the age of 65, and they have the benefit of that legislation during that time when they're not actually working or accruing any further benefits.
And indeed, one of my clients did move from full-time to part-time prior to retirement. I don't take time at the moment. You'll find it on the list to see that. So it's the absence, if I can put it this way, of the inclusion of part-time service into qualifying judicial office all the way through. It goes through to the point at the end. And to anticipate what I'm going to be saying very shortly as a complete response to my friend, his case is built on a distinction between acquiring rights by doing work and what the Court of Justice thought was critical in O'Brien, which is when the legal situation becomes definitive. And clear that the court said the legal point becomes definitive, legal situation becomes definitive on retirement.
Can I just be clear on 8A, a contract, term in a contract is less favourable. Are you saying that this is a contractual situation and or analogous to that, or are you, I mean, you referred us to on page 2897, to the statutory provision. One view might be that the statutory provision is not about contracts, it's about giving you a right to a pension at a particular time based on previous service. And so in a sense you might be saying, well, that's the time when your rights are acquired or not acquired. Under the statute.
If I may say so, it's not necessary to over-analyse this between contract and detriment. I have no idea what this court will do on Gillam, but you've argued through and you may reach a conclusion. There is a contract, there may not. The key point here is that there was a statutory scheme that applied to full-timers which did not apply to part-timers. You could, by analogy, and this is my lord's the first part of your suggestion to me, you could say that's like a statutory term of a contract, for instance.
Yes, but I mean, your complaint is that when you come to qualify, at least you hope to qualify for a pension at retirement, you discover that there's a statute which gives your colleague a pension and doesn't give you a pension.
That's the point.
And that's your point.
And that's all that matters in the end. But you can say the absence of that statute, including the part-time work, while the time you're doing the work, is also a detriment. It crystallises, you can say exactly what the detriment is, and it's when it matters is at the point at which the legal situation becomes definitive, which is on the point of retirement. So we say if you analyse it in that way, which is both logical and we would suggest highly sensible, because it will stop people thinking they've got to litigate at some earlier stage. One can see all sorts of situations which might arise. Not every one of us will live until we're 65. I'm glad to say I've passed that point. But if you've got no dependents and you don't live to that age, do you litigate? Do you not litigate? If all those sorts of issues arise. But anyway, I've made my point about Regulation 8. We say it's quite capable of dealing with this situation. We set out the opposing arguments at 25. We point out, and this is, I think, really important, if I just run through 27 on page 2902, a full-time judge doesn't get a pension at the point of transition. None of you, when you moved up through the judicial ranks, got entitlement to a pension. You hadn't retired. The Act didn't bite. You could, of course, say, I have an expectation that if my service continues and I qualify under it, but you didn't have a right at that point. We made half the point that Lady Hale made about the terms of the pension in B. My friend says, well, there's, as it were, no permission under the Pension Act for rights to be diminished, but there's the other side of the coin. There's no doubt about it that rights do change. And indeed, the final salary rate could go up, could go down, it could go sideways, it could go in all sorts of places. That's point B. And we make the obvious point, it's not ascertainable or due until the comparable FD judge retires. So that's the way that we, as it were, answer the points in summary form. We make the submissions in relation to the linkage in the next passages about how the past situation had come about and the Miller, and I think I can probably skip over that fairly quickly because it's, I hope you've had a chance to read it and you can see the logic of the approach. The argument then proceeds really to say, well, partly this has already been decided in Walker and Innerspec, and I want to pick it up, if I may, in Walker, first of all, at 2908. Now, it's noteworthy that my friend spent about a minute and a half on Walker, and he seems to think that if you took, I think it was my Lord Carnworth and Lord Hughes's careful final judgment in which you reserved your position, that if you took that position, then Lord Walker wasn't helpful. But what we would like to say is that you can't do that. You've got to look at the whole of the judgment, because in Walker, precisely the same argument that he's advanced today about effective turnover was advanced. Exactly the same argument. And it was dealt with extensively by Lord Kerr in the judgment that he gave. We've dealt with this fairly shortly because we've asked you to read it, I'm afraid, time permitting. But if I just pick it up at 53, and then the key passages in which Lord Kerr considered the turnover line of argument are 22 through to 46. And then if you look at the conclusion at 56, Mr. Chamberlain, counsel for Mr. Walker, submitted that the appeal tribunal wrongly took A.G. Van Gerven's description of pension benefits as deferred pay as equating the time at which a pension right accrues with the time at which any discrimination in the provision of resulting benefits is to be judged. Pause there. That's exactly the argument you've heard this morning. I agree that the appeal tribunal was wrong to do so. So the submission that was made this morning on turnover has been rejected by the majority of the court in Walker and Innerspec, in terms. The point of unequal treatment occurs at the time that the pension falls to be paid. My submission, Lord Kerr says it in terms. If Mr. Walker married a woman long after his retirement, she would be entitled to a spouse's pension. He goes through the facts. The period during which he acquired that entitlement had nothing whatever to do with its fulfillment. So the point is the fulfillment of the rights. And we say the fulfillment of the rights for the comparable full-time person is on the point of retirement. Can I, for your notes, just give you these references? Lord Kerr in Walker went through all of this at pages 2952 at paragraph 32, 2963 at paragraph 35, going on to paragraph 43. Indeed, we've said all the way through to 46. And the rejection, the explicit rejection of the turnover line being relevant to this argument is at paragraph 44 on page 2967. It would be completely wrong to suggest that the Court of Justice were not aware of the argument and indeed the conclusion of this court in Walker and Innerspec. It was appended, the whole judgment was appended to the observations that we put in front of the Court of Justice. So if you could just go to page 3711, and Ms. Krasnow has helpfully found that for me, and I can't now remember, I think it's in the third volume of Authorities. Pretty sure that's right. Yes, it is. So 3711 is where our authorities, our observations started to the Court of Justice in the O'Brien reference. And if you'll go to paragraphs 21 to 25, you can see exactly what we said to the court. (21) through to 22, and then the submissions that follow through at 25. And it was appended to the judgment so that the court had it. You will also see that Lord Kerr didn't just found his rejection of my friend's submission on his understanding of the case law following turnover. There was a case called Paris that my lady and Lord Reed may remember. But also his interpretation of two cases, Roma and Maruco. I don't want to open both of those to you, but perhaps for your note, 57A, that's when we deal with Maruco, the judgment at paragraph 62 at MS 2971 is particularly relevant.
What do you say about what Mr. Kavanagh said, seeking to distinguish Walker? It was very hurried, but his point seemed to be based on the fact that Mr. Walker had only entered into the civil partnership after the end of his service.
That's entirely the point.
There was no question of discrimination during service, so clearly this was a case where the discrimination arose later.
He simply doesn't do justice to what the case was about. I should say, I sat through it because the two cases were heard together. Walker and Innerspec was heard at exactly the same time as O'Brien and Ministry of Justice, and we made parallel submissions, Mr. Chamberlain and his team, and my team for Mr. O'Brien. The argument in Walker and Innerspec went like this, that the company in Walker and Innerspec was willing to provide a pension of a very small amount to Mr. Walker's same-sex spouse, calculated by reference to the amount of service that took place after the transposition date for Directive 2048. That's the framework directive on discrimination. 78. I always get the race one and the sexual orientation one mixed up. What the company were not prepared to do was to pay a pension calculated by reference to the period of service prior to the transposition date. The Supreme Court all agreed that the pension that was due to the same-sex spouse in due time would be calculated by reference to all the period. So it's exactly the same argument as in O'Brien about transposition. And that argument about turnover was rejected in the way that Lord Kerr has done it, and indeed in exactly the same way as the Court of Justice have done it in O'Brien. I think that just about does it justice. I'm looking at Lord Reid and Lady Hale, but I can go further into it if necessary.
Yes, it's important to read the passages concerned in the context of what the argument was about.
Absolutely. So it's not right to say that the only point in the case was, do you look at it at the point of the marriage? The argument was actually accepted that by the company that some survivor's pension would have to be paid to the spouse. The key point was about the amount of it that would have to be paid. So that is the rejection of turnover that it was in Walker, and it's in the context here that Lord Kerr says in terms that the point of unequal treatment occurs at the time that the pension falls to be due. You will see that in paragraph 56 in my box, in the judgment, and in my box at paragraph 54. So then we get to the cross-heading on O'Brien, CJE2, which is at paragraph 59. The passage at 19 to 20 in Lord Reid's judgment is in paragraph 61. I don't need to reread it. And in 65 and 66, the reasoning and the question are set out. And it was following that this court, through the registrar, wrote a letter to us saying that Miller was to go on hold pending the outcome. So that brings us to O'Brien 2 in the Court of Justice. And of course, you're going to need to read that carefully and decide what it means. But we say it's not that difficult. What the Court of Justice did was to draw a distinction between doing time, working, on the one hand, and the point at which a legal situation becomes definitive. And that's at the end of paragraph 35, and it held the critical thing was, when does the legal situation become definitive? And it's perfectly clear that's finally on the point of retirement. That's consistent with Lord Kerr in Walker, and it was consistent with our submissions. And I dare suggest that Lord Reid has that point in mind with the first question that was put to my learned friend: what about the situation with somebody who does his part-time work prior to the transposition date, but the retirement takes place after the transposition date? If my friend was right that the legal situation was definitive at the point of moving from part-time to full-time work, then an extraordinary anomaly, you'd have to have your 3 months at a point when you had no rights at all because the directive didn't apply, which would be absurd. And it's not what the court ruled. My friend couldn't answer that point.
But isn't his answer that there's a just and equitable extension?
Well, just an equitable extension to what? Because
To give you the right to do it.
the answer is that on his argument, the rights become definitive, say, in 1993, but at that point, there is no part-time workers directive. There is nothing on which a primary time limit can bite at all on his argument. That's the point. You only get to the secondary time limit of the just and equitable extension if the primary time limit has finished. And if it can't start, and it wouldn't start, this is my Lord Reed's point, if it doesn't start, there's nothing for a just and equitable extension to bite on at all. I hope I've not done ill justice to Lord Reed's question, but that's how I understood it in the way that it was put. So I'll take you at speed through this. I mean, paragraph 72, the court sets out the argument. This is in box on page 2913. The Court of Justice repeated that the Supreme Court, in the reference, thought it was unlawful to discriminate against part-time workers at the time when a retirement pension falls due for payment. And I make this point. There's absolutely nowhere in the judgment in which that is controverted. And you might have thought, on my friend's case, that it would have been expressly controverted. Third, if you read the operative part, which, as we all know, is the key part of any Court of Justice judgment, the Part-Time Workers Directive must be interpreted as meaning that in a case such as that in issue in the main proceedings, the periods of service prior to the 7th of April must be taken into account for the purpose of calculating the retirement pension entitlement. And we say that shows it rejected the argument for the United Kingdom and the MOJ that the discrimination only took place and the concomitant right to equal treatment only arose when the work was done and not at the point of retirement. Then we say, fourth, the Court of Justice differentiated turnover in accordance with Lord Kerr's judgment in Walker. Then we get the passages at 32 and 33 that the turnover line, it was a confusion, in short, to bring that into the argument. The turnover line of argument, 32, circumstances of the case are different from those that the origin of the case is giving rise to those judgments. It's important in this regard to bear in mind the matter of the retroactive effect of a rule of law cannot be confused with that of the temporal effects of a judgment of the court. As the court pointed out in Barber, the circumstances to which a restriction on temporal effects is subject relate to the existence of serious difficulties that may be created by that judgment. And then fifth, in 36, in a situation in which the accrual of pension entitlement expends over periods both prior to and after the deadline, it should be considered the calculation of those rights is governed by the provisions of that directive. So that, of course, is effectively what was said in the operative part. And then we analyse under the next cross-heading what we understand to be the argument that is made by my learned friend. And this all turns on paragraph 35. So in their case, and our case was a response to their case, although I'm afraid it comes before it in the core bundle, it was written as a response. We pick up on the fact that they took one part of paragraph 35 without the whole of paragraph 35. My friends tried to deal with that, of course, in his oral submissions, but we say ineffectively. And the passage that we say is critical is in italics in paragraph 85 in the whole, where we set out the whole of 35. It's only subsequently, and by taking into account relevant periods of service, that the worker can effectively avail himself of that right with a view to payment of his retirement pension. And that is a statement, effectively, that the legal position becomes certain at the point of retirement. There is, of course, something that we must all remember. Judgments of the Court of Justice are written first in French and then debated and then translated. And it is, I suppose, possible that the Ministry of Justice have been confused by the use of definitively and definitive in two different places. So it's used as an adverb in relation to acquiring, and that must mean no more, no less than the work is done. You've done the work at that point. But it's the legal situation that becomes definitive, which is critical for the judgment itself. And we say in paragraph 86, frankly, that's key to the appeal. Once you've got that the legal situation becomes definitive on retirement, you take it into account what Lord Kerr said, that really is the end of it. And I could go on at great length, but honestly, I'm not sure that I can make it any better than what I've said in that way. I'm happy to field any questions on the Court of Justice judgment, but then I need to deal with the other points that have been made by my friend.
Are you going to say something about the cases like Barclays Bank and Capital?
Exactly so, I'm going to. That comes under the fresh points, so the preliminary points, and I was going to go through that. We identified in their case, depending on how you parse what they've submitted, it's either 5 or 6 points. And if I just go through that fairly swiftly, we've identified them in paragraph 87, and what I will do, in fact, is really run together two of the points, as we shall see in a moment, by reference to the case law. The first proposition, which was put into the submissions at the time that this was initially argued, was that pensions are deferred pay. And that submission was made by reference to 2 cases, Air Jamaica and, I've forgotten the name of the other one, and Parry and Cleaver. And we can look very shortly at both of those. It will take no time at all to do that. So if you will go to Parry and Cleaver, first of all. That's at page 3458 in the bundle. It's also at 763 if you've looked there in the previous authorities bundle, but we'll take it at 3458 if I may. This is an authority which I suspect almost all of us, if we ever did any PI, will have had to think about at some point. It concerned the question whether insurance payments are to be offset against the entitlement to compensation on a personal injury case. And the key judgment of Lord Reid had to engage with the fact that the plaintiff in this case had been forced out of the police service because of an injury which entitled him to a disablement pension long before his ordinary retirement age. And the ultimate judgment in Parry and Cleaver was that up to the point of his retirement, the disablement pension was to be treated as insurance and therefore was not relevant to the assessment of compensation. There was no offsetting. But thereafter, it was to be treated as pension and therefore partial payment in relation to his loss of earnings that might have occurred had he continued to work after the police retirement age. That's the effect of the judgment. You can see Lord Reid's judgment on that between F and G at 3459. And there's really, I don't think it's necessary to go through the whole of the judgment. The judgment starts at 3470. The questions posed at B, the distinction between insurance and benevolence on the one hand and pay on the other is at F to G on that page. And then really the rest of the judgment deals with that. And the question was essentially answered by saying that the disablement pension became equivalent to pay, deferred pay, on retirement for Mr. Parry, but because he'd made a contribution towards it, it was like insurance up to the point of retirement. It really doesn't add to this case at all, in any way.
Well, does the label itself carry the matter very much?
I don't think so. No, but I have to answer the point, so that's our short submission on it. 3283 is probably, Air Jamaica at 3283 is probably of even less relevance to this case. That case, Air Jamaica and Charlton, was a case concerned with a trust fund which had been set up in parallel to Air Jamaica Limited, into which employees paid contributions. And there was a question about the rule against perpetuities in that case. The idea that that a pension payment was deferred pay was simply a passage in passing in Lord Millett's judgment. And again, we say that doesn't help this case at all. So if we then go to B, in the argument against us, that the entitlement to a pension is accrued at the time of service, this is the point at which the fee-paid judges were working for lower total remuneration. And take it with C, time starts around for limitation periods, and indeed D, because all of these will run together. We want to make submissions, first of all, by reference to Kapoor, and then also a short passage in Sharma. So can I start by asking the court to take the Court of Appeal judgment in Kapoor, which you will find at Volume 2, Tab 14, page 3299. The facts of Barclays Bank and Kapoor can be put quite simply. There were a group of, I think, 5 employees of Barclays Bank who'd all worked overseas. A point came at which they were brought back to the United Kingdom, principally from Kenya, but not all of them came from Kenya, where they'd been working in overseas branches of Barclays Bank. They were paid a lump sum and then told that under the Barclays Bank pension scheme, they would not be entitled to take into account their period of service prior to returning to the United Kingdom. Now, the critical fact in Barclays Bank and Kapoor is that the return to the United Kingdom took place prior to the commencement of the Race Relations Act 1976. I'm doing this off the top of my head, but I think it was the 31st of December. It doesn't matter, but it was before the date. The argument was that they had suffered race discrimination. The counter-argument from Barclays Bank was, if you suffered race discrimination, it occurred at a point when the Race Relations Act gave you no rights. And the rebuttal to that was to say, you had a policy, i.e. your pension scheme, which you applied to absolutely everybody, which said that service overseas would not be brought into account on retirement in the calculation of the pensions. So that was the rebuttal argument. And there was a strikeout application in effect. The merits of the case were not argued at this point. They were later argued. But the merits are not discussed in this litigation in these 2 cases. So it was argued by distinguished counsel on both sides, Ian MacDonald and Jane McNeill for the individuals, and then the future Lord Justice Underhill for the bank. And the facts are set out, the different situations are all set out at 3307 through to 3309. And it's worth noting, and I'll come back to this, 2 of the individuals had actually retired by the time of the claim. Not all of them, but 2 had. And then, if you can look, please, at Lord Justice Neil's judgment, first of all, at 3312, from A through to E. It's argued on behalf of the applicants that their case can be put in a number of different ways, sufficient if one of those ways brings the case within the provisions of the 1976 Act. I should say that the time limit provision in relation to the 1976 Act is very, very similar to the part-time workers regulations. I think it's section 68, which is set out at section 68 is at 761C on the internal numbering, and 765, so that's at 3307. And then it expanded at 765, so that's at pages 3311. But I'm going to pick it up in the judgment, if I may. Lord Justice Neil, could be said that a relevant act occurred when the terms of their employment were settled, but this was many years before the Act came into force, and clearly the time bar would then apply. In the alternative, it could be said that there was a deliberate omission to include any provision for a discretionary pension in respect of the period served in other banks, but this deliberate omission had to be treated by reason of section 68(7)(c) as having taken place when the original decision to omit such a provision was taken in the early 1970s. So he's positing the bank's argument. Another way of putting the case, however, it is submitted, is to say that they've been subjected to continuing acts in relation to their employment, which have continued throughout the period. Their lack of pension rights, equivalent to those of European comparators, has meant that they have throughout their employment been discriminated against in the way in which the employer has afforded them access to benefits. Alternatively, their continuing lack of comparable pension benefits amounts to being subject to a detriment. Therefore submitted that it was right to regard the applicants as being subjected to a continuing regime which gave them unfavourable pension rights as compared with Europeans in a similar position. The position was similar to that of a person who on racial grounds was prevented from using some staff facility. In such a case, the deprivation would be a continuing deprivation, and it would not be any answer to complaint. That deprivation had first occurred more than 3 months before the complaint to the Industrial Tribunal was lodged. In my judgment, this argument on behalf of the applicants is sound. If these applicants had been paid at a lower rate than Europeans, this discrimination would plainly be a continuing act of discrimination. Seems to me that the right to a pension forms part of the overall remuneration. If the pension entitlement can be shown to be less favourable than that of the employers, this disadvantage continues throughout the period of his employment. In the case of the 2 applicants who've now retired, their right to a pension can be judged at the moment of retirement, which in both cases was less than 3 months before the date when their applications were lodged. I say nothing at this stage as to the merits of the claim. So Lord Justice Neil is, of course, the point of interruption between different kinds of jobs doesn't arise in this case, but he certainly sees the critical point being the point of retirement. Lord Justice Bingham didn't expressly refer to Lord Justice Neil's judgment. He gave a short judgment, really dealing in a slightly different way, but with how you might reach the same destination. But you can see his conclusion, paragraph E, 769. These were cases of continuous and cumulative disadvantage. And Lord Justice Mann, likewise, and we can pick up his judgment on page 770 at 3316. The Employment Appeal Tribunal didn't feel obliged to follow the decision in earlier case law, They emphasize the perceivable difference to which I've referred. I regard the position of the applicants as being similar to that of Mrs. Calder. Throughout their service, and in 2 cases throughout their retirement, the applicants are subject of, as Mr. MacDonald put it, a continuous regime which is open to the bank to alter at any time. And whether that regime is racially discriminatory, is unlawful, are not matters for decision. So actually Lord Justice Mann would have gone further and would have said, even after retirement, you continue to suffer discrimination. Well, if I get home on my argument, I don't need to make that case any larger, but you can see entirely why Lord Justice Mann should have taken that approach. The matter went to the House of Lords, and there's a single judgment given by Lord Griffiths. But I want to pick up a point in the argument from Mr. Underhill, just to show you that he does pick up one of the arguments that my friend hasn't made orally, but which he's put into his written submissions, suggesting that if retirement is the critical date, these claims are premature. You've read that in the case. And that argument was deployed in Barclays Bank and Kapoor. You can see that he makes that argument at page 359, at the foot of the page H. That's at 3321. 3321. As to whether the 2 applicants who've retired can rely on the facts of their retirement, the fact that they have in fact received lower pensions, if that were the only act, then the other applicants' claims would be premature. Diminished payments are not in themselves, however, actions of discrimination, but the consequence is the working out of them. And that is the second submission that my friend makes in his recent case. So he says, until retirement it's possibly premature if we're right, to which our answer is no. The tribunal has declaratory powers. It can say in declaratory terms that the absence of part-time workers within qualifying judicial office is discrimination. And then he says that the payment of the pension is simply the consequence. And what we will see in due course is that Lord Griffiths doesn't deal with either of those 2 arguments. He doesn't consider them material. Now, just while we're on page 3321, you can see that Mr. Underhill's submissions between C and D sets out the argument from Lord Neil's judgment, saying that's the argument he's got to make, the key argument that he's got to address. So I won't go through the whole of the rest of the arguments. It's not necessary to do so. If we pick it up, Lord Griffiths' judgment at page 3328, Barclays submit that it was at the point of moving from Europe back to this country. Then there's a review of 2 other authorities, Amy's and Calder, which I don't need to deal with, because Lord Griffiths' judgment disposing of the appeal is at D through to F. In the present case, page 3331.
3331, yes.
In the present case, the Court of Appeal were, in my view, right to approve these 2 decisions and to classify the pension provisions as a continuing act lasting throughout the period of employment and so governed by subsection 7b. The matter can be further tested by taking the case of an employee before the act was passed, paid lower wages to his coloured employer than to his white employers. Once the act came into force, the employer would be guilty of racial discrimination if he didn't pay the same wages. If he continued to pay lower wages, it would be a continuing act lasting throughout the period of the coloured employee's employment within the meaning of subsection 7b. A man works not only for his current wage, but also for his pension. Require him to work on less favourable terms as to pension is as much a continuing act as to require him to work for lower current wages. Now, we did argue, both of us, about this before the Employment Tribunal, which reached the conclusion that it actually didn't quite touch the point in the debate, because, of course, in Kapoor, there wasn't a question of changing jobs during the period of time. Our short submission is there's absolutely nothing in Lord Griffiths' judgment contrary to my submissions, and Justice Neil's approach, which is not treated as being entirely wrong by Lord Griffiths, suggests that it goes up to the point of pension, at least. Lord Justice Mann suggests, if anything, it goes further.
How does Lord Griffiths deal with the two retired people?
He doesn't deal with them.
He just
He says it's not a problem. I mean, because once he's reached this position, it just was not a problem. They could bring their claim. So we've submitted below. This helps us. We certainly submit it does us no damage at all, for the reasons that I've tried to explain in those submissions to you. So that's Kapoor. And that brings me back, I think, just to deal with Sharma very shortly, because Sharma is the case which in which there's a holding that you can give declaratory relief prior to the point of taking your pension. It's tab 24 in volume 2, page 3576. Got that right?
Yes.
Facts very shortly. These were part-time lecturers in the Respondent Council's Adult Education Service employed under contracts. The hours were reduced following a reduction in funding for the Adult Education Service. They claimed that as part-time workers they were treated less favourably, since their hours could be reduced in a way which did not apply to full-time employees. The counter-argument that was put by the council was, well, we haven't done it yet, so your claim is premature. And the judgment is the then Mr. Justice Elias, who was president of the Employment Appeal Tribunal, obviously went on to the Court of Appeal. And if you look at page 3581, paragraph 20, and they lodge their claims. In each case for the establishment, they complained both about the fact that the contractual terms were less favourable, since they could be reduced, and then a separate point about actual implementation. And then the argument saying that about the fact is dealt with in paragraph 40 on page 3584. So Mr. McCluggage, who was counsel for the council, says the premise of the argument is false. Regulation 5.1 doesn't allow an employee to challenge a less favourable term itself. The part-timer can only complain about his treatment, which is less favourable. So he was making the counterpoint to my friend's argument, saying it's only at the later stage, and the court rejected those submissions. Mr. Justice Elias's judgment on the point is at 45 and 46 on the next page, 3585. It's open to a part-timer to challenge the terms of the contract, whether or not they've had any immediate practical impact upon him or her. So you can bring your claim earlier, and you get a declaration. So if I could just return to the passages, then to the argument about consequences. My friend makes a point saying that there's a distinction between the less favourable treatment and its consequences, and he relies on a case which I lost many years ago called Sugrin, and Sugrin is in the bundle at tab 25, MS 3589. The facts in this case show a clear distinction between with those in Barclays Bank and Kapoor, they can be summarized in this way. There was a process of regrading staff in the Haringey Health Authority. Nurses were regraded. My client, Miss Sugrin, was, as I recall, a night nurse, and she didn't get the grade that she wanted and compared herself with another staff member. And she didn't bring her claim within 3 months of the regrading exercise being completed. And so I had to negotiate exactly the primary time limits legislation that you've already seen. The argument that was made against me was, if I can put it this way, a single ad feminem decision, a single regrading decision. It's not a case of a continuing policy. There was a regrading process. Once it was over, it was done. I sought to argue that, that it had caused her in various different ways to suffer long detriment thereafter, but the Court of Appeal were against me. One can look at the judgment of Lord Donaldson, really, or indeed one can start at Lord Justice Balcom's speech at page 3596. Lord Justice Balcom said this was a one-off act. It was once and for all the regrading. And Lord Donaldson went into that, showed how I was able to make the submission and then rejected it at the foot of that page. I really don't have time, I think, to go through all of that. We say, I'd love to have re-argued it on a different occasion, but it doesn't do me any damage in this particular context once it's properly understood. So that's Sugrin. And that, I think, brings me to, really brings me through to E, which is a remarkable submission. Frankly, it's just a jury point that it's submitted against me that my friend's interpretation of Regulation 8 is not unfair, and we have responded at paragraphs 114 through to 115 at page 2923. It's no secret that my clients thought that the right time to challenge these issues was getting on for the point of retirement. At that point was when it was all going to bite and affect them. That's why they delayed until that later stage. They knew about the litigation in O'Brien's case. And one pauses for a moment just to remember some of the process of this litigation. It's actually what the Ministry of Justice itself asked judges to do. After the first judgment of this court in O'Brien, when it was discovered that part-time judges were entitled in principle to pensions, the Ministry of Justice issued a so-called moratorium, saying those people who had not yet retired and indeed who had not yet brought claims were asked not to proceed to do that. For a very good reason. It would just clog up the registry until all the issues had been resolved. And these people weren't the beneficiaries of that moratorium, but it really does point up the counterpoint to this argument. Anybody who was a judge would have thought that the Ministry of Justice post O'Brien 1 would have wanted to have put in place a comprehensive reformation of judicial pension law. In fact, what's happened, and I understand there are difficulties about funding and how it's done through delegated legislation and so on, but there have been practical difficulties in relation to that. But to say it's fair to impose this rule in the way that my friend suggests, we suggest it's not going to dispose of this appeal, and it is wrong. And that, I think, brings us to the last point, which my friend makes, which is another bad point, frankly, in our submission, which is to suggest that the issue's all been resolved by the original Court of Appeal judgment in O'Brien. That's not advanced. Well, then I don't need to answer that question, that point. And that is our last bit from F onwards. As a matter of disposing of my duty to the court, our collective duty to the court, we did find one subsequent judgment in this country which has dealt with O'Brien CJE 2. It's a judgment of the Court of Appeal. We don't think you're going to be particularly assisted by it, but you probably ought to know it exists. It's called Emerald Supplies, and it's on the bench. You've also had it emailed to you. I think you've all got a copy. I hope so. It's a huge piece of litigation concerning allegations by those who'd had to ship, that's the wrong word, it isn't the wrong word, those who have sent freight, shipped freight by airlines. And they said there was a cartel amongst the airlines. That's the background to this. And they've claimed damages for having, in short, had to pay too much money for the shipping. There's no doubt at all that after Council Regulation number 1 of 2003, there were potential rights to seek damages under Article 101 of the Treaty on the Functioning of the European Union and its predecessors, what is now 101. But prior to that date, the remedy was not by a damages action, but by various complaint systems. And the argument that was put forward in this case was to say, now we've read about the future effects principle and the Court of Justice's decision about how it works, we can say that the damages that we suffered prior to Regulation 1 of 2003 coming into effect had effects after that date, and so we can bring our action for damages in relation to that. I don't know, but I think the matter is not subject to an application for permission to appeal. I have spoken to one of the counsel in the case subsequently to the judgment earlier this year, but I say that to you because it's possible, bearing in mind the amount of money, that it might come to you in some form. But for what it's worth, the Court of Appeal had to consider what the Court of Justice had said about O'Brien, and because O'Brien was the premise for the future effects principle argument that was put forward. And if you'll turn to page 3823 on the internal numbering in the One Weekly Law Reports version of the judgment, you'll see Lord Justice Flo saying, contrary to the submissions advanced on behalf of the claimants, nothing in the recent CJEU judgment in O'Brien which supports any erosion of the well-established principle that substantive rules don't have retroactive effect. I agree, the future effect principle is not in some way an erosion of the principle. It's complementary to the no retroactivity point, and the complementarity in Lord Justice Lewison's judgment is then cited, and then Lord Reid will recall this, the Moravia gas passage, which you cited in O'Brien, is then put forward and referred to. And at paragraph 110, the Court of Justice considered the future effects principle applied in the O'Brien case because O'Brien's pension rights didn't become definite and crystallised until he retired. And frankly, those are two other ways of putting that what we've put in the submission, saying that his rights were inchoate until the point of retirement. They were prospective, conditional and inchoate, as you'll have seen we've said in the submissions. By that stage, in 2005, the relevant new law in the form of the regulations giving effect to the directive was in force. Not to give effect to the future effects principle in that case would be to deprive the directive its intended full effect, not least because Mr. O'Brien was entitled, under the directive, to be treated no less favourably pro rata than a salaried judge retiring on the same day. So you can see Lord Justice Flo fixed his concept of the less favourable treatment on retirement. Of course, in Mr. O'Brien's case, the comparator is easy to identify. The relevant comparator would be a full-time judge who'd served for 27 years, not a full-time judge who'd only served 5 years. Here we have a more complex set of comparators, but I'm not saying this is dispositive of the appeal, but it certainly doesn't harm me. It's consistent with the way that we've put the case and what we draw out of the Court of Justice. My lady, I think that's probably my time up, and even with my 3 extra minutes, as it were, would you allow me just a moment just to see if there's anything I've missed?
Thank you, Mr. Allen. Ms. Krasno?
No, nothing further.
Thank you. Mr. Kavanagh.
My ladies, my lords, just a few points in reply. The first concerns the question of what happens in the middle bit. My Lord Wilson's question about what happens in the period between the end of service, if there is one, a gap between the end of service and the point at which a person takes their pension. My learned friend said that the less favourable treatment carries on through that middle bit, despite the fact that the individual is not in service and they're not yet of pensionable age, and so they're not losing out on pensions. In our respectful submission, that means that during that middle period, there is no series of similar acts or failures comprising the less favourable treatment, which is going on, which is taking the language from Regulation 8.2. Nothing at all is happening in that period. There is no less favourable treatment. And the mismatch between my learned friend's submissions and the way in which time limits work is helpfully indicated by the example adopted by the House of Lords in the Kapoor case. Can I take you back to it? We haven't looked at this passage before. It's page 3330, and it's in volume 2, tab 15. The House of Lords in Kapoor examined 2 Employment Appeal Tribunal cases and approved the conclusions that were set out in them. The first was a case called Amy's and the Inner London Education Authority. She suffered sex discrimination because she wasn't given a promotion. And in relation to time limits, the question was whether time ran from that moment or whether time did not run until the end of the period in which she'd remained in the more junior job. And in the text from the judgment of Mr. Justice Bristow against Letter E, the learned judge said that like any other discrimination by act or omission, the failure to appoint her and the appointment of him must have continuing consequences. She's not the head of department. He has been since October 75. But it's the consequences of the appointment which are the continuing element in the situation, not the appointment itself. And that was compared with a case called Calder and James Finlay, in which there was a continuing policy of not granting mortgages to women when they granted mortgages to men. And at 3331D, his lordship said, in the present case, the Court of Appeal were right, in my view, to approve these 2 decisions and to classify the pension provisions in Kapoor as a continuing act lasting throughout the period of employment and so governed by subsection 7b, the equivalent of 8.2. So applying it to the present case, if there is no continuing act when an individual remains in the lower job because of an act of discrimination, then a fortiori, in our respectful submission, there's no continuing less favourable treatment when you're not working at all. You're not part of the judicial structure. And the case of Sugrin that my learned friend mentioned is just another example of that. There's a difference between the act of discrimination and the fact that the act of discrimination is hanging over you. And in our respectful submission, the very fact that my learned friend has to contend that less favourable treatment is continuing, even in this period of abeyance, is a sign, we say, that his submission is not right in law. As for the approach taken by the House of Lords in Kapoor, that's made clear in the passage that I've just read from, that the continuing act lasted throughout the period of employment. It's a bit of a mystery about what happened to the two individuals who retired, but it's clear from that paragraph and from the last sentence in that paragraph that the House of Lords regarded time as starting to run from the end of the period of employment, which of course is what we say happens, should be applied to the present case. The second main point in my reply submissions is just to develop my submission on Walker on Innispec, which, as my Lord said, was rushed a little bit at the end of my main argument. We do submit that there's nothing inconsistent in our argument with the conclusions that were reached in the Walker case, which was not a time limit case. My learned friend in his submissions, if I may say so, was treating our argument today on time limits as if it was the same as the argument that was advanced on behalf of Innispec in relation to the future effects principle. Now, we've lost future effects, but time limits is a different argument. But the key point about Walker is that Walker is a case about the future effects principle where the less favourable treatment had nothing to do with service. Cases like Walker are not straightforward retirement pension cases where the pension is earned by service. These cases, Maruco and Roma also, involved further special benefits which are contingent on events which are separate from, independent of, service. Because in relation to those further benefits, there is an additional qualifying requirement, nothing to do with service, which is marriage or civil partnership. And in those cases, even if you marry long after your service is over, you still qualify for those additional benefits. And in all of those cases, the discrimination related to that other qualifying requirement, the requirement that you be married or have a civil partnership. So, in our respectful submission, one can't draw any conclusions from the outcome of Walker as regards the issue before this court, which is whether, for time limit purposes, relating to discrimination arising or concerning the service itself, whether time starts to run at the end of the period of service. And as I've mentioned, Roma and Maruco, very complicated on their facts, but their answer to them is the same. They were both about rights that you got through marriage or civil partnership, which you could acquire regardless of the point at which you married or entered into your civil partnership if you were heterosexual, but you were barred throughout if you were homosexual.
So why precisely, analytically, does that make a difference?
It makes a difference, my lady, because what we're dealing with in the present case is an act of discrimination arising out of service, where the only trigger, what we say the only trigger for your entitlement is the service itself. In Walker, there were two triggers for entitlement. The service itself wouldn't be good enough of its own. It's the service itself plus marital status. And so far as marital status was concerned, that could be acquired at any time. Doesn't have to be when you were working. In fact, in Mr. Walker's case, it was after he retired. So the trigger, the breach, happened in relation to the marital service in that case. Marital status, I'm sorry. Whereas in the present case, none of those complications arise. The breach is purely service-related. In Walker, there was no rule that a gay person's service didn't count. That would have made it the same as the present case, but that's not what the position was in relation to Walker.
position always was that if later he was to enter into a civil partnership, he would be unfavourably treated.
Yes,
It was always there as a contingency.
it was. It was, and I accept, therefore, that he could have brought a claim before he married. But the difference is that the ending of the period of limitation was later in that case, because if you were single and you had no desire to get married and then you retired, but 5 years later you decided to marry, at that point an act of discrimination takes place, but there is no equivalent act of discrimination in the present case. The only act of discrimination on our argument is when you are in service itself.
Surely the mere fact he had terms of service on that basis was an act of discrimination.
Yes, it was. It was. But there was a further trigger act. Of course, nobody would bring a claim unless they were in Mr. Walker's position. So the trigger for the claim was actually the fact that you did marry but yet were deprived of your right to claim. May I just make a couple of final and very brief
Can I
points?
just ask you one point, which I did put to Mr. Allen? I mean, whatever the position in relation to an ordinary contractual pension right, here, arguably, your only right comes from the legislation, which gives you a right at the point of retirement. You don't have any rights before that. You have a right at the point of retirement, which is then calculated by reference to various things, including period of service. Why isn't that when you're discriminated?
Well, my lord, the way this case has been advanced, as I understand it, on both sides throughout, is that there is no distinction to be drawn from the fact
Yes, I
that these are
understand,
statutory rights.
but it's troubling me. I mean, is that the right way to...
No, my lord, because it's still the fact remains that the only reason for your entitlement is the period of service that you completed whenever it was that you completed that period of service. What you get... Sorry, may I put it this way? I'm so sorry, I hope I didn't interrupt.
No, I was just saying, I mean, I do see that seems to be the way the European Court has treated it, and so it may not be a proper distinction.
Yes, I think some of them, I'm afraid I can't collect from my memory the name of the case, but I think at least one of the equal pay discrimination cases in the Court of Justice was based on civil servants with statutory rights rather than private sector contractual rights.
Have to survive to the age which entitles you to the pension.
But if you die before then you get a death in service benefit, your pension scheme will
But
pay out.
something different.
Well, my lady, it's still...
Doesn't carry us a right to have a civil partner benefit as a spouse.
No, my lady, but our respectful submission is that I use the expression locked in, that from the moment your service is over, you will get what you become entitled to. When I say what you become entitled to, because the age at which you retire is going to make a difference, the salary you were receiving in the last few years in this scheme will make a difference, whether you survive to collect a pension at all will make a difference. But one way or another, there is a bundle of rights that is available to you as a result of your period of service. And that, although the particular quantification of those rights isn't yet known, the fact remains that you are locked in, you are guaranteed whatever pension rights you ultimately get solely and exclusively and purely because of your period of service.
And if I said to you that that proposition runs completely contrary to the Court of Justice's telling us that the legal situation does not become definitive at the time of the service, you would tell me what?
I would say that in paragraph 35, the Court of Justice draws a distinction between definitively acquiring the rights, which is what I'm talking about, and the legal situation becoming definitive.
It doesn't tell us that Mr. O'Brien definitively acquired the rights. It's simply taking the government's proposition that where somebody, the argument was where somebody has had a period of service, they have definitively acquired the rights, and therefore that's it, frozen. And they were saying, well, that's a non sequitur.
Well, my lord, we of course respectfully invite the court to adopt a different interpretation.
Yeah.
And it's not just paragraph 35. In a number of the paragraphs leading up to it, there are references to rights being acquired during service and reference back to 10 over, which we say is the fountain of the guidance in this area. but our case does depend upon the submission that the rights are definitively acquired at the point of service. My Lords, my Lady, in the remaining 30 seconds, we say Emerald is of no relevance. It's not a case concerned with workers or retirements. It's not a case concerned with time limits. It's a case about the future effects principle, and it decided the future effects principle didn't apply on the facts of that case. And very finally, my learned friend said in argument that I couldn't answer the point about what happens to a claim relating to service, which is exclusively before the date for implementation. So may I just make sure the court have my 2 points on that. My first point is that, as I submitted in response to questions from my Lord Reid, we submit that the question doesn't arise because we submit that O'Brien means that there has to be some part of the service after the date of the law coming into force.
And you say some part of a part-time service?
Yes, indeed,
Yeah.
part-time service. But secondly, even if it does, the solution to this is in the just and equitable extension. Even on the premise that a cause of action can be based entirely on service many years before the law came into force, no claim could ever be made or would want to be made before the law arrived, because you'd never know the law existed. But as soon as the law comes into force, you're protected by the just and equitable extension. You're given a breathing space so that you're able to bring a claim within time, provided it's within a reasonable period of becoming aware or reasonably being aware that you have a claim. And my Lord, my last final attempt to emphasise my submission on why service that's entirely before the law coming into force doesn't count. And that's because that would be a very significant impact of the future effects principle. It would mean that somebody who was part-time service in the 1970s could avail themselves of a development of the law that happened in the year 2000.
Well, so it can, even on your submission, provided his part-time service continues over the magic date in 2000.
In those circumstances, the legal relationship, the inter se relationship between the judge and the individuals is still there, whereas if you go off to be a portrait artist or a landscape gardener in the late 1970s, in my respectful submission, it would be surprising, perhaps, if the future effects principle were to apply in those circumstances. May I just check? My ladies, my lords, unless there's anything more, those are my submissions.
Well, you're already well over your time, so...
I'm so sorry.
It's no doubt our fault, but never mind. Thank you all very much indeed. We will now go away and put our thinking caps on and let you know the result as soon as we possibly can.